5 things that lawyers are not allowed to do in a Colorado courtroom. Number 1, you're not allowed to say lie. You can say that a witness made statements that were contradictory to statements made by other witnesses. You can say that that person's testimony isn't credible or shouldn't be believed because it was different than a statement that they made earlier. But you can't get up and say that that person lied or is a liar. And the reason behind that is our Supreme Court has decided that the word lie necessarily implies that the person saying the word lie believes that person that they're talking about is a liar. And so there's a long-standing precedent where lawyers can comment on the evidence, but they're not allowed to give their own personal opinion about a case. You can't tell a jury, for example, I believe that this person is innocent or guilty, or I believe that this would be a right or a just verdict in the case. And our Supreme Court has taken that far enough to where in the early 2000s, in 2005 specifically, they put a blanket prohibition on lawyers calling witnesses liars or saying that they lied. Number 2, you can't actually go up and touch the bar in front of the jury box. I'm sure you've seen this on 100 different movies where lawyers giving an opening statement or closing argument, and they're leaning on the bar, they're touching the bar and running their hand across the bar as they're examining witnesses. They're hanging out by the jury the entire trial. I can tell you there is a blanket prohibition in Colorado on lawyers getting that close to the jury, and if you try to do that, a judge will yell at you immediately to get away from my jury. It's almost the word they always use, stay away from my jury. And the idea is that the jury is an impartial arbiter of the facts in the case, and if you're leaning on the bar, if you're running your hand across the bar, it can either look like you're trying to influence them or manipulate them or intimidate them in some kind of way. So a judge isn't going to ever allow a lawyer to get that close to their jury. Number 3, you're not allowed to talk about sentencing. Colorado divides out the fact-finding process in a trial from the sentencing process. So it's a jury in Colorado that decides whether or not somebody is guilty or innocent of a crime, but it's the judge who decides what the law is and who decides what the sentence is going to be if somebody is ever found guilty of a crime. Now, this is different from a lot of other states. In states like Texas and many other states throughout the country, juries will also get to determine what the sentence is going to be. And so in those states, lawyers will be arguing whether or not somebody should go to prison or whether or not they should be a sex offender following that charge. In Colorado, you'll never hear that from lawyers. They're entirely prohibited from arguing about what the sentence in somebody's case should or shouldn't be. Juries will never know if a particular conviction is going to carry mandatory prison time or the requirement to register as a sex offender or anything like that. That is only for a judge to determine. So any lawyer that tries to argue whether or not this is an appropriate sentence for a defendant will immediately be chastised by the judge, and it could result in the case being mistried and having to be tried all over again in front of a new jury that never learned that information in the first place. Number 4, lawyers aren't allowed to speak to the jurors or refer to them by name once jury selection is completed. So jury selection is where we pick a jury, and you'll talk to what's known as the veneer, the group of people brought in as potential jurors in a case, ask them a bunch of questions about their personal experiences, look for things like bias or prejudice or a willingness to follow the law or vice versa. But once that process has been completed and a jury's been selected, those lawyers will never be allowed to talk to the jury again while the case is continuing. So if we see jurors in the hallway, we put our head down and run scared past them because that's an absolute prohibition. And you can't even refer to them by their name. So if I'm examining a witness, I can't tell that witness, hey, Mr. Witness, please tell Juror Jones what you saw that night. And the idea behind it, again, is that the jury is impartial and doing those kinds of things like developing a relationship with the jury, even if it's innocuous enough as telling them what's a good place to get lunch or asking the witness to tell the juror this specific piece of information. That can start to sound like currying favor or developing a relationship, and that can influence somebody's verdict. So judges put an absolute prohibition on lawyers or the parties in the case from talking to the jury once they've been selected. 5, and the final prohibition is that lawyers are prohibited from asking jurors to disregard the law. So that's also something known as juror nullification. That's where jurors decide that somebody's guilty, but for whatever reason, they're going to acquit the defendant anyway. And so there's been famous trials in the past where somebody was put on trial for homosexuality when that was illegal and that kind of stuff. And lawyers made arguments about this being an unjust law. That's not something that lawyers are allowed to do. Whether or not the law is just or unjust is outside of any arguments that lawyers can make to a jury. A jury may still decide that, and jury deliberations are confidential, so we never find out as to what they actually talked about unless they volunteer that information. But lawyers are not allowed to put pressure on the jury to decide whether or not they believe that something should be a law or not. We're a representative democracy. We have legislators who go and pass laws on our behalf, and we're bound by those laws, and jurors aren't supposed to be the ones rewriting the law when they're making a determination on how their verdict should be. So the idea is that guilt is measured based on the facts of the case and not what the law should be. And there's a really famous example you'll hear from prosecutors all over the state where they're trying to illustrate this point to potential jurors in jury selection. They'll ask them, hey, if somebody was charged with going 1 mile over the speed limit, would you convict them of that charge, assuming that, the evidence supported it? And there's a lot of people that do a lot of eye rolling, but the point that tries to get across is that even if something sounds ridiculous, it's not a juror's place to rewrite the law. So those are the 5 things that lawyers are not allowed to do in a Colorado courtroom. My name is Austin Lux. I'm a criminal defense attorney. I practice in Colorado Springs, Colorado, and I want you to know your rights and know the law.